Okay, I call the committee back to order. I understand we are now televised, and we will proceed with the order of the day pursuant to the order of reference of Tuesday, December 10th, 2013, Bill C-479, an act to amend the Corrections and Conditional Release Act, Fairness for Victims. Our first witness today, we'd like to welcome Mr. David Sweet, MP for Ancaster, Dundas, Flamborough, Westdale. Mr. Sweet will have 10 minutes for his opening statement. Please proceed.
Thank you, Mr. Chair. Colleagues, Madam Ombudsman, ladies and gentlemen, it's an honor to be here today before this committee to talk about the important amendments to the Corrections and Conditional Release Act that I've proposed in Bill C-479. First, I'd like to acknowledge the Honourable Parliamentary Secretary, MP Roxanne James, and those honourable members of this committee who rose to speak to Bill C-479 during the second reading in the House of Commons. I sincerely appreciate your commitment to victims and the comments you made during debate and have taken them to heart. Mr. Chairman, let me also recognize the good work of our professionals in the correctional system. They deserve our gratitude, particularly those of the Parole Board of Canada who work hard and make extraordinarily difficult decisions to keep our communities safe. And speaking of professionals, I'd like to thank and acknowledge Sue O'Sullivan, the Federal Ombudsman for Victims of Crime, who will speak to the committee after me today. I'm grateful for her advice and wisdom in crafting this bill. Her work in the police services as Deputy Chief and in the community working with victims has been a tremendous asset to all Canadians in her current role, and to me in the development of this bill. I'd also like to make special note of my former legislative assistant, Stéphane Rose, who's here today and took the day off his present job. He spent multiplied hours in helping me with this bill and deserves public commendation for his investment into helping victims of Canada. Mr. Chairman, I'd like to start off today, just as I have at every opportunity to speak to this Act to bring fairness for victims of violent offenders in the House of Commons, by talking about the reasons I brought this bill forward. I know you've maybe heard it before, so I'll spare you all the details. However, for the record, it's what focused my efforts and instilled in me the passion about this bill. Over the years, since my election in 2006, I had a number of people call, email, and come to see me face-to-face about the imbalance in our justice system as it pertains to the treatment and rights of offenders versus that of victims. This became a policy concern of mine, which began conversations between my colleagues, ministers, and myself on what could be done. However, none of my previous conversations so focused my efforts as did an unforgettable experience in the summer of 2010. Constituents from Ancaster, Ontario, the community which I live, invited me to attend the hearing of the Parole Board of Canada with them. The matter at hand was the case of John Rallo, an offender who is the brother-in-law of my constituents and the murderer of her sister, her niece, and her nephew. This well-regarded couple, known for their generosity in the community, wanted their federal representative to see firsthand what they had to go through on an annual or biannual basis for far too long, to see the extent of the voice they had been given primarily through the victim impact statement in that meeting. They wanted their federal representative to see all the aspects, raw as they are, of a parole board hearing. I can tell you, Mr. Chairman, the anguish of my constituent reading her victim impact statement was something that one could not imagine without being present to experience such an event. Every time Mr. Rallo has reapplied for parole under the current process, my constituents have been there. I joined them again in 2011 and again last summer in 2013 in the Federal Penal Institution in Gravenhurst, Ontario, where the most recent parole board hearing for Mr. Rallo took place. The hearings are never easy. Each time, my constituents tried very hard to be composed. Inevitably, before uttering a word, she'd start weeping. The memories of a crime committed over 30 years previous always came flooding back. It was a grisly triple murder. Her sister, her niece, and her nephew had been murdered by her sister's husband, Mr. Rallo, violently and viciously murdered. After killing his wife, this violent criminal suffocated his two young children, a 6-year-old boy, 5-year-old girl. To this day, his son's body has never been recovered. At each Parole Board of Canada hearing, my constituent would ask the same question of Mr. Rallo: why did you kill your family, and what did you do with your son? She is yet to get a response. Despite being convicted on evidence that was very substantive and clear, Mr. Rowley does not feel any remorse, nor has admitted any culpability. Each time he has sat stone-faced through the victim impact statement. And Mr. Chairman, despite the obvious pain of my constituent, her husband and parents, they feel an overwhelming duty as a family to attend each hearing. They must do so to honor the memory of their daughter, sister, grandchildren, niece, and nephew. Mr. Chairman, I believe they are an appropriate representation of every family that deals with a similar situation here in Canada. Having been robbed of their loved ones, I can attest today that certainly every victim I have spoken to has shared similar trauma, pain, and feeling of helplessness, as well as a steadfast feeling of duty. For me, Mr. Chairman, this underscores so resoundingly that our federal parole process unwittingly, I believe, makes the re-victimization of victims and their families an all too frequent occurrence. Determined to help strengthen the voice of victims and modify the parole process, I talked to victims' advocates, law enforcement officials, and legal experts in researching this bill. It was a common theme that the provisions in the Corrections and Conditional Release Act that may have made sense in the past, it was established, by the way, in 1992, no longer reflect Canadian society today, in particular, offering respect and dignity to victims. In developing a well-researched and well-thought-out bill, I spoke numerous times with the Federal Ombudsman for Victims of Crime in her office. When her report came out last June entitled Meeting the Needs of Victims of Crime in Canada, I took an extensive look at it. Her recommendations on the rights of victims to good communication throughout the system, the use of technology and victim statements presented at parole board hearings, and ensuring the parole process is more accommodating to victims' needs are reflected in Bill C-479. I'll defer to her expertise to make these parallels more clearly. However, it wasn't her expertise alone that underpins this bill. My office and I spend a lot of time speaking with legal experts, and we believe this bill has a sound legal and constitutional foundation. And it has broad support in the modernization of 9 provisions in the Corrections and Conditional Release Act. This is reflected in a look at what our other jurisdictions are doing as well. The Victims' Rights Act of New Zealand, instituted in 2002, has been a model for the world. Under the corresponding provisions of the New Zealand Parole Act of 2002, rights of victims are also enshrined, much as is being proposed in Bill C-479. Similarly, the basis is support and respect for victims. In 2009, the New Zealand Ministry of Justice launched an extensive public consultation to further enhance their victim support within the justice system. And, Mr. Chair, if I may say, that's why I was very happy that the Parliamentary Secretary and the Minister did just this last summer. I won't list every area of commonality. However, one of the areas they looked at is echoed in Bill C-479 are the modernizations I propose to reflect the use of technology. Through video conference and links to oral statements delivered in regional offices via telecom. This is expressly addressed to ensure victims have a strong voice in the process, but also to mitigate the re-victimization of victims and their families. The Victims of Crime Reform Bill introduced to the Parliament of New Zealand include this provision. Mr. Chairman, the New Zealand Victims of Crime Reform Bill passed by the New Zealand Parliament in August 2013 also included improvements to their victim notification system, which are also reflective of provisions of Bill C-479 to Canadian victims, increased access to information about how offenders are progressing with their correctional plans, and pertinent documents. However, our Kiwi friends aren't the only ones looking at this issue. I know the report by the Office of the Federal Ombudsman for Victims of Crime looked at U.S. legislation at the federal and state level. The UK Code of Practice and 2012 European Directives of Victim Support and Protection were also studied. I raise these not to suggest that we in Canada should be followers rather than an international leader on victims' rights, especially when it comes to victims of violent offenders, but because they illustrate that this is a debate taking place around the world, in other Commonwealth and allied countries, and so our efforts here today are timely and appropriate. Mr. Chairman, colleagues, it's imperative to understand that this bill is targeted at helping victims have a more clear voice within our justice system, as well as give Parole Board of Canada more tools to deal with offenders. But not just any offenders. Please keep in mind when we discuss this bill and the new latitude we're giving the Parole Board of Canada that these are offenders who have caused grievous physical harm, maimed someone for life, were attempting to murder or did murder victims or a victim. I'm talking primarily, not entirely exclusively, but primarily about the likes of the Clifford Olsons and his devastatingly painful victim count, the David Shearings, who killed an entire family, the David Dobsons, who savagely killed Dolly Prioriello, and the Monroe brothers, who shot, held, and killed Constable Michael Sweet. The parole board should have the capability to extend reviews in these kinds of cases, where these heinous crimes are committed and parole is either a faint option or certainly a very distant one. And certainly, Mr. Chairman and colleagues, after the Parole Board of Canada grants parole and the offender breaches parole or outright reoffends, surely they should have more discretion than they presently have now. This is not just a matter of victim fairness, but overall public safety as well. Mr. Chairman, for me, this is where it comes full circle. When we look at the facts, the previous experience of countless victims, we can look at the precedents, what other countries are doing. We can debate the language and the clauses of the bill. But ultimately, when we're talking about victims of violent crime, we're talking about people. Victims are not a number, nor are they a burden to our system. Mr. Chairman, the justice system is daunting enough, and victims should never feel they're just a cog in the process. It's very personal. It's very emotional. I urge the committee throughout the study of Bill C-479 to never lose sight of this point. Yes, let's study the bill. Yes, let's make sure it makes the modernizations to the Corrections and Conditional Release Act that are necessary. Mr. Chairman and colleagues, I welcome any amendment that is well-intended and will strengthen the language and the principle of this bill. So yes, let's work together to strengthen it with amendments that are required. But let us never, ever dishonor or diminish the experience of people most affected by the perpetrators of violent crime. The people who never asked to be in this unfortunate circumstance and who would give anything to turn the clock back. These are the victims, and C-479 is for them. Merci beaucoup. Thank you very much.
Thank you very much, Mr. Sweet, and thank you for keeping quite closely to the time. We'll now begin our first round of questions of 7 minutes. We'll turn to Ms. James.
Thank you, Mr. Chair, and thank you, Mr. Sweet. I would like to thank you, first of all, for bringing this important legislation to committee and for standing up for the rights of victims, and I congratulate you for getting your private member's bill to committee. I know from experience how difficult that is, and I have to commend you on the content of this bill. In your speech, you talked about a particular offender, John Rallo, and you had mentioned that the crimes had taken place 30 years ago, and they had actually attended parole board hearings with the families of the victims, family members of the victim, and you'd actually gone in 2010, 2011, and 2013. That's 3 times in a very short period of time. What do you think this does to the victims and the victims' families?
I would encourage all members, if they have not been to a parole board hearing because of the nature of it, to attend a parole board hearing and experience it. You have the professionals from the parole board up front. I think, in fact, the room is generally about 1/4 the size of this, so it's very intimate. And then you have the offender who's facing the parole board officials, and then you have the family behind. And the family has the right. And like I said, you've got to understand, too, that if this hadn't happened to any of us, if you've ever, I don't know if anybody here has been victimized, but you would certainly feel like you're the standard bearer. You need to make sure that their memory lasts on, and so they feel this compelling duty to be there. And yet, it's a feeling that's contrasted with this terrible thought that they're in the same room with the person that took their loved one, or loved ones, plural, in this, particularly in Mr. Rallo's case, away. And so you don't even need to participate in the hearing just to be there to experience the pain and trauma. And so, you know, one of the things that a meeting brings home to you very clearly is that once someone is victimized to this degree, it changes their life forever. They're never the same person, and they always will feel this loss for the rest of their life.
Thank you, Mr. Sweet. I guess leading up to a secondary question, the people who come into the parole board hearings, the families of the victim, they must have an idea that that individual is not going to get a positive, they're not going to get their parole bearing a positive outcome of that hearing, and yet they show up time and time again. In your actual opening remarks, you had mentioned, and I'm just going to quote this, the parole board should have the capability to extend reviews in these types of cases. You're referring to the most heinous, most violent, most severe cases. And you said, you went on to say that parole is either a faint option or certainly a distant one. Now, the Parole Board of Canada may realize that. The families that are coming there to provide their statements realize that. How is your bill going to put an end to this type of just repetitiveness that's really, I think, unnecessary?
Well, thanks for the question, and maybe I should also justify that statement too up front. The Parole Board of Canada, one of the things that I did witness being there over and over again, I know some people publicly have criticized the Parole Board, but I've noticed a very high level of professionalism. These are people who are trained very well, those who are on the review panel, and they, of course, have tens of thousands, I would hazard to say probably hundreds of thousands of case precedents that they have access to, so they know what to look for in regards to an offender when they're coming before the parole board, what efforts they've made to rehabilitate, the kinds of ways that they have communicated publicly in regards to those that they've harmed, etc. And so they have a good idea going forward of the kind of case that they're dealing with. And as for those who go into the parole board meeting, again, it's a conflicted emotion that they have as well. They're hope against hope that the person stays there, depending on the feeling that they have in regards to if he has not taken the steps to rehabilitate, if they're afraid for their own personal safety when they're released, etc. But they don't really know. They have no idea what the outcome is going to be at the parole board, how the offender is going to testify, and so it really is kind of going into a very scary void for the family, the victims, when they walk into the room and they're presented with this very official procedure.
Thank you. How much time do I have, Mr. Chair?
A little less than 2 minutes.
Okay, thank you. I wonder if you could speak a moment to why it's important that victims or the families of the victim receive the requirement for mandatory disclosure of the date and time and conditions of the release. Why do you think that's so important, that the families or the victims themselves, if they're not deceased, if the victims and the families, why do you think it's so important that they know that information?
Well, the victims that I spoke to, the reason why they would like that information is they feel that they have their own personal safety is in jeopardy, and if the person returns to the place where oftentimes where the crime happened is, of course, where the family resides, this is where the offense took place, and they want to know if the person's coming into their area and what kind of restrictions they have, so that they can make sure that they can take appropriate action to preserve the integrity and safety of themselves and their own family. So I know that even one of the videos on the Victim Ombudsman's website has a good dissertation about that. Colleagues, I'd encourage you to look at that website and see that, in fact, the one gentleman I watched on there, if I recall correctly, that he was on a business trip somewhere and found out that the person who was the violent offender who had victimized his family was actually released in the same area where he was on a trip and hadn't been informed about it. So these kinds of things terrify people. They know the capability, obviously, of these individuals, and they're concerned that they'll perpetrate another crime again. And unfortunately, they're afraid that it could be against themselves or their own family.
Thank you very much, Mr. Sweet. We'll now turn to Madame Doyle-Lefebvre for 7 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. And I'd like to begin by thanking Mr. Sweet for coming here today to go into detail about the bill that he has sponsored. That is Bill C-479. Victims' rights is something we are studying today. This is an extremely important issue, and we take this very seriously. Victims' rights are something that must be taken very seriously. I do, however, have some questions. Today, in the House during the question period, a question was put to the Minister of Public Safety with respect to the Victims' Rights Charter that the Conservative government had promised more than a year ago. This was part of the 2014 budget tabled by this same government. I was wondering if it would be prudent to go ahead with this type of legislation, this private member's bill, which calls for a slight modification to victims' rights, when in fact we have this Charter of Victims' Rights that's just been announced. I don't know if you can tell us, but do you know to what extent this bill is going to be tied to this eventual Charter of Victims' Rights? And if there is a linkage with this charter, why not wait until we see what this charter is going to be about once it's tabled by the government?
And there's a couple of elements there I want to respond to. One is I know this Minister of Public Safety. I know he's dedicated to victims, and I know that if there's any delay in the passage of time, it's because he wants to get it right. It's, as I mentioned, the Corrections and Conditional Release Act, which is only one aspect that affects victims. Of course, the Criminal Code does as well. Is one that was developed and passed in the legislation in 1992, and so there's probably a significant review that needs to go on before making sure that that's complete. I don't know every detail of how they're doing it. They haven't. I haven't had direct consultations in that regard. In regards to this bill, I do want colleagues to know that this is a private member's bill, that in fact there was an iteration of this before in previous Parliament, but we went to an election and it died on the order paper, and so we're fortunate to get to this stage this time with this bill. As far as how it will affect the Victims' Bill of Rights, I think I can only speculate. Like I said, I don't know what that's going to entail, but I think it would only serve to support any initiative that is taken with respect to a Victims' Bill of Rights, because of the nature of the amount of research that we did. I think it will just complement it.
D'accord. Sur un autre d'idée.
On another line of questioning, you said you consulted quite a few people, that you spent a great deal of time working on this bill. You mentioned a few groups, including the Ombudsman for Victims' Rights. Did you consult the Parole Board of Canada before you drafted this bill?
Members of the Parole Board of Canada. I did not sit down directly with the Parole Board of Canada itself, but I did talk with some of the professionals that actually adjudicate the reviews.
Et ça a été quoi leur réponse face à ce...
But how did they react to this bill?
Positive on some of the discretionary tools that it would give them, and they were appreciative that I would take the initiative with my own private member's bill to move that forward.
Excellent.
That's good. You seem to have a good understanding of how the National Parole Board, about the Parole Board of Canada works, and the importance of conditional release as a way of helping someone be reintegrated into society. The extension by putting off some of these hearings, don't you think that that may discourage inmates from going ahead with their correctional plan? And if I may, do you think that by increasing the deadline or the amount of time between these hearings, do you think that the offenders would be released sometimes without any checks being done at that time?
That allows me to make sure that I clarify another thing, that all the language in the bill is up to. So that's why I say it gives them discretion. It does not limit them to have a review or a hearing earlier than the 5-year period. It simply gives them that discretion in order to do that. As far as discouraging, I would hope that it would actually encourage offenders to get busy on their corrections plan and be ready to be able to show that they're worthy of a parole board hearing and at the most expeditious time, and that they're prepared to go out and be contributing Canadian citizens. I think one of the things that I often see in some of the criticisms about those of us who are, how would I say, victims advocates, is that the people think that it's mutually exclusive, that you're either for the rehabilitation and reintegration and betterment of society by having inmates who are, like I said, rehabilitated, educated with the tools so that they can live successfully, and being advocates for victims. I don't see it mutually exclusively. I think that one of the best things you can do for Canadians, for victims, is to make sure that offenders are released in a way where they're not going to be detractors from society anymore, contributors. And I don't think this bill in any way, shape, or form limits the capability of offenders of doing that. Like I said, it only gives the Parole Board of Canada discretion.
Do I have time for a very brief question? There's one little aspect in this bill that I would require some clarification for. Does the bill give victims the right to attend conditional release hearings if the general public does not have access to them?
That right now, the provisions of the Parole Board of Canada is that anyone from the public can apply to attend a parole board hearing. The bill simply states that it enshrines in legislation that a victim has the right to. Right now, there's policies in place. I simply want to clarify some things in law to make sure that the message is clear that a victim has that right.
Thank you very much, Mr. Sweet. We'll now turn to Mr. Norlock for 7 minutes, please.
Thank you very much, Mr. Chair, and through you to the witness. Thank you for being here today, Mr. Sweet, and for this piece of legislation. And if you don't mind, I know that some of the young people might fall off their chair when I say this, but some 44 years ago when I was a young police officer, I can tell you that very little attention was paid to victims of crime. As a matter of fact, I don't recall ever there being even victim impact statements until well into my career. And of course, today we do have a whole plethora of services to victims in our court system. And I think what you're doing with this bill is accentuating the responsibility of not only the offender, but to the feelings and to society's relation to the victim. And making sure that the person is adequately prepared, as you just recently said in your testimony to Ms. Lefebvre. And so I want to get into some of the meat and potatoes of the bill now, if you don't mind. And there's a couple of questions, but I'll run the first two together. So I was just wondering why you feel it's important to expand the mandatory review period from 2 to 5 years for violent criminals, and I think you specified violent is an important part of this. And beyond that, could you also discuss why it's important to expand the review period following the cancellation of termination of parole?
Well, in both cases, it's a case of trusting that the Parole Board of Canada has the capability of looking at a file and determining what offenders are ready to be released on conditional release or day parole or full parole prior to them coming to the meeting. Now, that is not to say that the offender's testimony, that the victim impact statement, and other evidence that's heard at the hearing does not make a difference or even a substantive difference. But there is a lot of pre-work that's done. I think the one file that I saw in the one parole board hearing that one of the review panelists brought in was almost a foot thick. that's how much research they had done on the particular offender, and so they know how to look and evaluate who is ready for these different types of releases. And so whether it's an inmate who's coming for their first hearing after serving a sentence, or whether it's an offender who has breached their parole or outright reoffended, in either case, I believe we can trust in the capability of the parole board to know whether an immediate review should be done or whether time should be taken for the offender to access the programs, to make more significant advancement on their rehabilitation program than what they have. And that's simply why that provision is in there. And why this would benefit a victim is why subject them to a hearing when it's simply going to be a no anyway. So that's why that discretion is there. I think the foundations of what's going to happen at the hearing, they have a good handle on.
Thank you very much. A follow-up question. Could you explain to the committee how important it is to tighten the language? And I know you've said, I've tried to be succinct, you want it to be somewhat prescriptive but yet not restrictive with regard to this piece of legislation. So I wonder why you felt it important to tighten up the language with respect to the importance of the parole board while making every effort to fully understand the needs of the victims and specifically the victim's family.
Well, I think victims, first off, need to know that that's legislated. Let me quote from the former victims ombudsman who, in a publication, iPolitics, said, it's important to legislate this right if we believe victims are entitled to have their voices heard and respected. He was commenting on the fact that it was already the policy of the Parole Board of Canada for a victim to give a victim impact statement, but he was saying nonetheless, this is important to legislate if this is to be a right we believe victims are entitled to. So for me, these things, policy can change, management of institutions can change. Legislation tends to be a little bit more concrete. Sends a very clear message, and I would hope that, if anything, it would give a positive encouragement to the Parole Board of Canada to even go farther than they are right now at a mindset of being conscious of the victim being part of the process. I go back to the comment that you said that it's still an evolution as far as understanding that the victim is part of the whole process, and it's a real recent evolution. It's not something that's been around for 50 years, as you rightly said from your experience as being a police officer 44 years ago.
Thank you very much. And thank you for what you said to a previous witness's question, because a lot of talk around the Hill and we political types, the suggestion is that we're really not interested in rehabilitation. And of course, this is actually, and I think you articulate this, and I wonder if you wish to expand on it, it's actually a part of the rehabilitative process.
And that's exactly correct. The Parole Board of Canada is there. If I can quote to you a document that was made to explain the 1992 provisions of the new Corrections and Conditional Release Act, and it says, one of the most significant aspects of the CCRA is an articulation for the first time in legislation of the purpose and principles of corrections and conditional release. As expressed in the Act, the primary purpose of the federal corrections system is to contribute to the maintenance of a just, peaceful, and safe society. Further, the first principle to guide the CSC in achieving this goal states that the protection of society is the paramount consideration for all decisions relating to the release and treatment of offenders. And then it goes on to say that, that the CCRA also takes into consideration the rehabilitation of offenders and the safe release of offenders so that, in fact, that they can become contributing citizens and be builders of the Canadian society rather than detractors.
Thank you very much, Mr. Sweet. Now we'll turn to Mr. Easter for 7 minutes, please.
Thank you, Mr. Chairman, and welcome, Mr. Sweet. I might say, in beginning, I have attended parole board hearings, and it can certainly be a traumatic experience, no question about that. And I don't think most people realize the professionalism and the amount of work that parole board appointees really put into a hearing. What you see at the hearing itself is the tip of the iceberg in terms of what they do and what correctional officials do in terms of preparing the homework before you have the before you have the hearing. I would say in the beginning, though, you, Mr. Sweet, know my concern with the avalanche of private members' bills that is coming forward from backbench Conservative members. I think it's something like 16 that impact the criminal code. You are members of the government. Sounds like the parliamentary secretary, who is the representative of the minister here, is fully supportive of this bill. And what I can't understand for the life of me is why these discussions on these private members' bill aren't done in a comprehensive way within the governing party and brought forward as comprehensive amendments rather than one-offs to the Criminal Code of Canada. Because one error on our part as a committee, Mr. Chair, on a private member's bill could in fact have the the opposite effect of what is intended. And I know your intent here is value. I mean, we've had experience with this before. One private member's bill that was just dealt with a Justice Committee had 6 amendments on a 5-clause bill coming from the Conservatives. So I lay that out, and I guess I would ask, Mr. McKenzie has a bill as well, C483, and he has taken the position in his bill that the parole board be responsible for all temporary absences rather than the warden. So he's taken responsibility in that bill from the warden passing it over to the parole board, which means more work for the parole board. Your bill is somewhat going the other way in terms of, I think, trying to lessen the workload of the parole board. Is there any contradiction between the two? Is there any discussion within your caucus if there's a conflict here? Or?
Well, thank you very, very much for the question, Mr. Easter, and you can please accept my commendations for taking the time to go to a parole board hearing. It's a long, arduous meeting. I know that because I've been in them, and you leave, even as a participant, I should say as a bystander, a very different person. Let me also say that although I know you have this position and you've characterized it that way, and that's okay, you're allowed your opinion, that all of us, you know, are allowed to have our name in a lottery, and our names, and most of the people in the public don't know that that's how we end up being able to get a private member's bill. Our name is pulled out. The first time I think I was about 206. That's why my bill didn't make it. I was fortunate. I think it was 99 this time. And then the private member is allowed to pursue something that they're really dedicated to make this a better Canada. Most of us ran for office because we were idealists. We wanted to make this a better country. We wanted to protect the innocent and bring to justice those who would purport to do people harm or actually do people harm. And so my pursuit of this bill was one of personal endeavor to help victims, and I'm just glad that I'm with a party who is of that same mind and has championed the rights of victims. And at the same time, you should note also, Mr. Easter, that I come from a community, Hamilton, where significant investments have been made by the National Crime Prevention Centre as well as the Human Resources and Skills Development Canada, organizations like the St. Leonard Society, organizations like Living Rock, organizations like Liberty for Youth, to help integrate those who have offended as well as to keep youth from crime. So there's been significant investments in that regard, as well as these initiatives to protect victims. I mean, we want to make sure we keep youth away from crime, because if we can prevent that, then people aren't victimized later as well. So I think there's a good balance between what the government's doing and also my right as a private member to pursue something that I'm concerned about.
You'll get no argument from me on prevention. I think that's where the government is going. So much wrong is they're not putting enough into
several
into
examples of where we were investing, Mr. East. I don't understand how we could be going wrong in that regard.
Yeah, I heard what you said, but when you look at the overall position of the government, I would question them.
Sure, we have a point of order from the Parliamentary Secretary.
We're actually here discussing a private member's bill, and I think that the questions coming from all sides of the table should be directed at that private member's bill, and leave your personal opinions with regards to other government legislation out of this committee for the time being.
Thank you very much, Ms. James. I don't believe that's actually a point of order, so
I
I'll
don't
return
think that's
to
a point of order,
Mr. Easter, and I will extend
But
this
anyway,
time.
with regard to the bill, Mr. Sweet, C479, under section 501(2), it says the board shall conduct another review, and the key words are within 5 years after the latter of the day, and goes on from there. And Mr. Norlock also raised this question earlier. So we know the maximum that the bill proposes is 5 years. What's the minimum period that the parole board could act on? Is it 2? Is it 3? Is it 4? I mean, does this really mean much when it says within? It doesn't say 5 years. It says within.
Absolutely. I think it means a lot. Right now, the parole board has discretion that the hearing, the hearing time within 2 years, as it is. And sometimes they actually do what is called a paper review. So I don't know if you've experienced that, but the hearing is one aspect of what they can do, but the parole board can actually do a paper review. And we had this circumstance, if you notice the gap between the times I visited the parole board, we had a hearing and the offender was denied day parole, and then in a paper hearing subsequent was actually given day parole. So they have a lot of latitude in regards to their operations. This simply gives them the capability of not, by statute, not having to have a review within 2 years, and so they can make that judgment. You yourself mentioned of all the great work that they do and the preparatory work that they do, and that gives them a good idea about where they want to go in regards to how to deal with the offender and stream them into the community in the best way, that they're not going to reoffend, that they're going to be rehabilitated successfully, and that the community will be safe. It's a win-win-win situation.
So,
thank you very much, Mr. Sweet. I have extended your time already, Mr. Easter. So we'll go to Mr. Rousseau for 5 minutes, please.
Thanks, Mr. Chair. Merci beaucoup, Mr. Sweet, d'être présent.
Thank you, Mr. Sweet, for coming here so that we can do an in-depth study of your bill. And I thank you for your openness towards the possibility of having various amendments. You know, we too want to support victims and their families, and we want to cooperate with them to ensure that we take measures, that we provide them with support services when it's time for a hearing. However, my first question is as follows. Could you tell us who, I understand your intentions behind the bill, but often these initiatives, these parliamentary private members' bills come about, and who came up with this idea of changing the way that this operates within the Parole Board of Canada?
There's 9 separate provisions in the bill which cover a number of things. The discretion around the parole board hearing came from multiple sources. One of them, of course, was my experience. Another one was a move that had been afoot. I think if you asked the Ombudsman in the next hour, she would be able to tell you, but I think it's over the last 15 to 20 years that victims advocacy groups were asking for the Parole Board of Canada to have more discretion and a longer term between hearings. And so the other provisions in regards to the information being available, I'll tell you the first place where I heard that from. The Toronto Police Association called me and told me about the terrible tragedy that happened to Constable Michael Sweet. And it was the murder in that case of a 6-year veteran of the Toronto Police Force was so heinous. He was flagged down by someone who was able to get outside of I believe it was a delicatessen, but it was some kind of public store. And the two Monroe brothers were holding hostages. And of course, you know, as any good policeman would, when everybody else was trying to run away, he ran into the situation and was shot twice. And then the Monroe brothers held him hostage and denigrated him and allowed him to bleed to death in front of all of the people who were held hostage. And unfortunately, the police weren't able to get their SWAT team there fast enough and get in to extricate him. They shot the two Monroe brothers. They took the 3 of them to the hospital. The 2 Monroe brothers survived, and Constable Sweet died. The one thing, the Sweet family stayed pretty silent through the whole thing. It devastated their family so much. But the one thing that they did ask for was that they could get some information about the inmates' progress in their correction plan so that they would feel that their family member did not die in vain. That's all they wanted. They spoke up after years and years and just said, you know, this isn't a privacy issue. This is an issue of public concern. The persons shot their husband in public. He died in public. They were tried in public and convicted in public. And she and the family were simply saying that this information about the person's rehabilitation should be made public so that the public and the family that was harmed could rest assured that all efforts are being made to rehabilitate, and they would feel that then at least their loved one didn't die in vain.
Excusez.
Pardon me? Unfortunately, one of the problems that we have in our system pertains to rehabilitation. We could talk about that to great length, but one of the consequences and undesirable consequences of this provision to extend this wait time to 5 years is for those who have long-term sentences. There may be some unwanted consequences for these people. Let's say for people who have lesser sentences and who don't have a hearing, and then there's no follow-up done on these people, and the victims have no recourse. How do you comment on that?
Quite a number of tools at their capability. The only reason why they would extend a hearing, and certainly the only intention of this bill, would be that they felt that the offender, the inmate, needed to make more progress on their corrections plan. And then if they haven't made appropriate progress in their corrections plan, they certainly and didn't warrant a hearing, they certainly wouldn't be eligible or wouldn't qualify as ideal candidates for conditional release.
Thank you very much, Mr. Sweet. I'm going to have to cut you off there. So I'd like to thank you very much for appearing before the committee, and a committee will hear additional witnesses and deal with your bill as expeditiously as we can. So thank you very much. Just before we suspend, I believe the Parliamentary Secretary has a motion to move that affects the timing of our next section.
Thank you. I was actually going to say that to the end of the committee, but we can do it while the committee is suspended. I actually move to go in camera to discuss future committee business.
At the end of the next section.
At the end of the next section.
Okay. All those, any other discussion? Sorry.
Sorry. Basically, we need 5 minutes at the
end of the next session.
Thank you.
For committee business, I see everyone nodding yes, except one. I believe it does not require unanimous consent, so we'll have a vote. All those in favor? We will have a recorded vote. Mr. Clerk?
Ms. James?
Yes.
Mr. Albus?
Yes.
Mr. McGuire? Yes. Mr. Norlock?
Yes.
Mr. Payne?
Yes.
Mr. Richards?
Yes.
Madame Doré-Lefebvre?
Oui.
Monsieur Rousseau?
Wait.
Mr. Easter?
No.
Motion is carried. So we will briefly suspend for just 2 minutes, give people a chance to get up from the table, and we'll reconvene as quickly as we can. So we will reconvene. We have our second witness on Bill C-479. So we'd like to welcome Sue Sullivan, the Federal Ombudsman for Victims of Crime, and ask you to make an opening statement of 10 minutes. I believe the members have it in front of them.
Thank you very much. Merci beaucoup. Good evening, Mr. Chair, members of the committee. Thank you for inviting me here today to discuss Bill C-479, an act to amend the Corrections and Conditional Release Act. I would like to begin by providing you with a brief overview of our office's mandate. The Office of the Federal Ombudsman for Victims of Crime was created in 2007 to provide a voice for victims at the federal level. We do this by receiving and reviewing complaints from victims, by promoting and facilitating access to federal programs and services for victims of crime, by providing information and referrals, by promoting the basic principles of justice for victims of crime, and by raising awareness among criminal justice personnel and policymakers about the needs and concerns of victims, and by identifying systemic and emerging issues that negatively impact on victims of crime. The Office helps victims in two main ways, individually and collectively. We help victims individually by speaking with victims every day, answering their questions and addressing their complaints. We help victims collectively by reviewing important issues and making recommendations to the federal government on how to improve its laws, policies, or programs to better support victims of crime. I would like to begin today by thanking Mr. Sweet for his work on this bill and for his efforts to recognize the valuable role that victims of crime have to play in the Canadian criminal justice system. As mentioned, my mandate is to assist victims of crime in Canada. During my previous and current term as Ombudsman, I have had the privilege of hearing from hundreds of victims across this country. I have found that victims are most concerned about their treatment, both within the criminal justice system and beyond. More specifically, I have found that while the needs and concerns of victims are unique and do vary, on the whole, victims want to be informed, they want to be considered, protected, and supported. It is clear to me that the intention of Bill 479 is to further consider and include victims of crime in our criminal justice system, and I fully support these aspects of the bill. I think this bill puts forward some valuable changes to the Corrections and Conditional Release Act that would significantly enhance victims' treatment and consideration in the process. Many of these changes are in fact in line with the recommendations that our office has made in the past. That being said, I think there are some minor modifications that would further strengthen the bill, and I would like to share these with the committee today. Bill C-479 aims to address the lack of information victims receive by providing them with more information about the offender who harmed them. This is done in part through the bill's proposal to shift the onus on the Parole Board of Canada, or if I may, PBC, from providing the information to victims on a discretionary basis to ensuring that victims shall receive it. I strongly support this amendment. However, I would suggest a modification. As written, the bill suggests that only certain terms currently considered discretionary become mandatory. I would suggest, as a further modification, that all of the information currently listed as discretionary be given to victims automatically unless there is a relevant safety or security reason not to. If the principle of the bill is to provide victims with greater access to information, then I see no reason not to include all of these items. Additionally, the proposed list of information to be provided to a victim includes information relating to the offender's correctional plan. We have often heard from victims who wish to know more about the offender's progress towards rehabilitation. Through the Safe Streets and Communities Act, Bill C-10 in 2012, some information about the offender's program participation and Serious Disciplinary Offences Report, or the PPDO, was made available to the victim at the discretion of Correctional Service of Canada, or CSC. However, the PPDO provides very little information for victims outside of the names of the programs offenders may be taking, their status, example, whether it's complete or ongoing, and blanket descriptions of the program's overall goals. The PPDO does not provide information relating to the offender's risk progress and overall rehabilitation, and this is the information that victims are most interested in obtaining. The correctional plan, on the other hand, provides much more comprehensive information that would be more meaningful for victims in understanding the risks an offender may pose, how those risks are being addressed, and what progress, if any, he or she is making towards rehabilitation. Given this, I fully support Bill C-479 and its proposal to provide victims with more information relating to the offender's correctional plan. As an additional note, many victims have expressed the desire to be informed of the commission of any new criminal code offences by the offender while under the supervision of CSC. As such, I would recommend that Bill C-479 be amended to this information. Finally, as a further modification to this area of the bill, there is an important technical oversight which could nullify the proposed benefits of the bill once passed. The bill proposes to expand the type of information provided to victims and includes an amendment to 142 of the CCRA, authorizing the Parole Board to provide information related to the offender's correctional plan. The correctional plan is a document under the control of CSC and is used to manage the offender while serving their sentence. Accordingly, our office recommends that CSC, rather than PBC, be authorized to provide this information through an amendment to Section 26 of the CCRA rather than only Section 142. Further, the same pertains to notifications to victims related to the date and destination of certain absences and releases, as well as whether the offender will be in the vicinity of the victim while traveling to the release destination. These are all currently pieces of information also provided to victims by the Correctional Service Canada under Section 26 of the CCRA, which is not provided for in the bill. In other words, I recommend the bill be amended to mirror the proposed amendments to Section 142 of the CCRA in Section 26 as well. While ensuring that victims are properly informed is essential, it is equally important to create opportunities for victims to participate in the process and to create an environment to encourage that participation. This means providing choices and options for how victims can choose to participate in the criminal justice system without feeling intimidated or fearful and without causing significant disruption to their lives and finances. One example of this is the parole hearing. Parole hearings can be extremely important to some victims, given that it is often the first opportunity since sentencing for the victims to learn more about the progress, if any, an offender has made towards rehabilitation. While some victims will find it important and even necessary to face the offender in person, others may find this idea intimidating or generally undesirable. In the current system, attending or observing the parole hearing in real time is the only way that a victim can attain the most complete information about the offender who harmed them and the progress they may have made. For those victims who are fearful and encountering their offender for any number of reasons, including fear of retaliation, there is a distinct lack of options for observing a parole hearing. Only in exceptional circumstances can victims request that they attend the hearing via video conferencing technology or closed-circuit television. Attending by secure webcast or audio feed is not an option. Bill C-479 aims to address this gap by proposing that in cases where a victim or a member of his or her family has been denied the ability to attend a hearing, the board shall provide for the victim or family member to follow the hearing by teleconference or by means of a one-way closed-circuit video feed. I would recommend 2 modifications to this. That the wording be amended so that it doesn't merely permit victims to follow the hearing, but participate by reading their prepared victim statements, and that the option for a victim observing and or participating in a parole hearing via teleconference, one-way circuit video feed, or via video conferencing or other technology be extended to all victims, regardless of whether or not they have been denied attendance. We must keep in mind that for some victims, work commitments, childcare, caring for elderly parents or family members, financial restraints of their own emotional anxiety about being within close proximity to the offender may prohibit them from attending a hearing. While the proposals in Bill C-479 are well-intentioned to provide victims with greater access to the hearings, they neglected to take into account the fact that for many victims, attending a parole hearing is not always an option, regardless of whether their attendance has been approved. This lack of options for attending a parole hearing in and of itself wouldn't be as problematic if a victim who did not attend the hearing had choices and options for reviewing the proceedings at a later date. The reality, however, is that there are no alternatives for victims in these cases. No transcripts are provided and victims cannot access an audio recording even when it exists. The only further material available to a victim who was not able to attend a hearing in person is a copy of the decision registry, which outlines the decision taken and main supporting reasons. It is in no way a full depiction of the information provided during the parole hearing. Bill C-479 recognizes this need and attempts to address it by providing that if a transcript of the hearing has been made, a copy of it shall, on written request, be provided by the board free of charge to the victim, a member of the victim's family, or the offender. Unfortunately, while this clause has the victim's needs in mind, our office understands that it is not currently the practice for transcripts to be made. Instead, audio recordings are kept as records of the parole hearing proceedings. As such, this legislative change would not result in further access by victims to the proceedings of any given parole hearing. Previously, our office has recommended that victims be granted access to listen in, not keep, audio recordings of the parole hearings, and that there be potential funding support to travel to the location at which these recordings are stored as necessary. As such, I would recommend that the wording of the bill be amended to state that victims, members of the victim's family, and the offender have access to, at no charge, any recordings, be they audio, audio-visual, or otherwise, of the parole hearings. In addition to increasing the information victims receive and their role in the system, Bill C-479 proposes to increase the time between parole hearings for violent offenders who are denied parole or who have parole cancelled or terminated. In 2010, our office released a report entitled Towards a Greater Respect for Victims in the Corrections and Conditional Release Act, which recommended that the time between hearings be extended to 5 years for those serving life and indefinite sentences if an offender's request for conditional release is denied.
May I ask you to
Okay, I'll just finish.
conclude your remarks?
Okay. All right then. In conclusion, I would like to reiterate my support for Bill C-479 and to commend the bill's efforts to address some of the gaps in information, participation, and consideration that exist in our current system of victims of crime. I feel that with the modifications I have suggested today, the bill could significantly help to enhance the treatment of victims of crime in Canada. I would encourage the committee to seriously consider my amendments and suggestions for technical modification to make the bill as sound and effective as possible. I thank you for your time.
Thank you very much. So we will turn first to Mr. Payne for 7 minutes.
Thank you, Chair, and my questions to the witness through you. Thank you for coming today, Ms. O'Sullivan. And I noted in discussion when Mr. Sweet was here, he did say that he talked to a number of members of the parole board. I'm wondering if you were one of those individuals that he talked to try and gather information to help craft his bill?
Well, as a matter of fact, we had a technical briefing by Mr. Sweet, yes.
Okay. All right, thank you. And I know during discussions, Mr. Sweet did talk about attending parole board hearings and the difficulty that the victims have had. And I'm wondering if you could maybe sort of tell us some of your experiences that you've had with the victims attending these parole hearings and some of the difficulties that have been expressed by Mr. Sweet, and what your comments are on those.
Yes, I too obviously have had the opportunity to attend parole hearings and have spoken with victims. And I think Mr. Sweet spoke very eloquently to some of the experiences that he had had. And I can reflect some similar experiences. And I would go further to say that we often talk about the day of the hearing and the emotion and all that's attached to that. When you speak to families and family members who do feel that obligation to attend because they're representing the person that can't be there, they'll talk not just about the day of the hearing. It's the months in advance. It's the year in advance. Are they going to apply for parole? Is the hearing going to actually take place? Is it going to be canceled? Do I need to amend my victim impact statement? So it's not just the day of the hearing. And then, of course, once the hearing takes place, and then the after of that as well. So this is a huge toll that takes place. And, of course, one of the things that this bill is trying to address is, if I was to say, and I use those 4 words, victims are looking to be informed, to be considered, to be protected and supported. And so a lot of the pieces of this, number one, victims need information. They need information on the offender who harmed them. They want to know, and a lot of the pieces that are here, they want to know, if the offender is, while in the institution, is taking proper steps towards rehabilitation. Not just that he took a course and it was completed, but was he engaged in that? What is the risks that have been associated to this offender? Is it appropriate, the responses towards rehabilitation? And conversely, if in fact they're not. So they may want to take extra steps when they get back into the community. They need to know that when they're being released back into the community, be it on a pass or be it on parole, that in fact, what are those conditions attached to that? Because if there's a condition that says they're not to communicate with the victim or their family, then they need to know that. If there's a geographic specification, they need to know that. And so it really comes down to their right to be informed so that they have the information they need to feel safe. And when it talks about, for example, a parole board, considering a victim's safety in their decision making and looking at that, that's some of the things we hear from victims. They want, how do I know that those board members have considered my safety when they're making that decision around release? So I think a lot of the things that this bill is bringing forward, and if we were to look at the specific amendments, and so for example, when I talk about the Corrections and Conditional Release Act, Section 142 gives direction to the Parole Board of Canada. Section 26 gives that authority to Correctional Service Canada. So you have those 2 sections over 2 federal agencies that both are involved in, the offender, both the management side and the correctional plan, as well as the conditional release issues. And so what I'm saying is that there are some things, for example, like a work release. So that is the decision through Correctional Service Canada of the warden to issue one of those. And so we should really have reflective in 146 and reflective in Section 26. The authority, the governing authorities, should have the ability, because they can only give a victim what the legislation says they can. And so when you look at something like a correctional plan, and I've listened to victims who the first time, and it was in my earlier testimony, that they hear, the first time that they hear about whether an offender is being retained often has been the parole board hearing, which might be 20 years down the road or 15 years down the road. And so what they're saying is Correctional Service Canada has that correctional plan early on. So if they have the authority to give that information to the victim earlier in the process, then they can assess those risk issues and are they being engaged towards the rehabilitation. So it would make sense. These modifications that we're recommending is that 26 and 142 grant both those authorities the mirror ability to give that information to victims of crime.
Well, and that does make a lot of sense. And certainly we've heard over and over about victims and the difficulties that they've had, and particularly on release or temporary release. So that's really, really important. I just wonder if you could touch a bit more on the video piece. I'm just trying to find that here. You talked about one-way circuit video feed or via video. How do you see that whole thing working for the victims? And I know that certainly travel might be an issue for individuals. And just how do you see that particular working to help the victims?
So our recommendation is...
Response, please.
Sorry?
Just a brief response.
Sure. Our recommendation is that any victim or family member that wants to attend a parole hearing should have a choice and an option about how they wish to attend. That can be in person, They may choose to attend by video conference or by other use of technology, and they should have a choice to do that.
Thank you very much. Et maintenant, nous avons Madame Doré-Lefebvre.
Now, Mrs. Doré-Lefebvre. Thank you, Mr. Chair. I'd like to thank Mrs. O'Sullivan for coming here today to discuss Bill C-479 and victims' rights. I know that you do some incredible work as Ombudsman in improving victims' rights. I'd like to thank you for that. Before I begin my questions, I would like to ask you whether you were taken a bit aback by the provisions with respect to wait times between reviews. Did you want to add something? I know you didn't have enough time to state everything you wanted to say in your preliminary statement.
Has recommended, and that when it comes to persons charged with murder and with indeterminate sentences, that it be 5 years. What was added to this legislation was Schedule 1. And it's my understanding, I am not an expert in offender management, but it's my understanding that when some people are released back into the community to be under, obviously it can have benefits to be under supervision. However, this bill also does say within 5 years. So if the board is cognizant that some of those benefits, but I would certainly defer, the best approaches to offenders being back in the community to people with that offender management expertise.
Merci beaucoup.
Thank you. I think victims have good reasons for wanting to attend certain release hearings, particularly in cases where it's probable that the offender is going to go back to the same community where the offense was committed or where the victims live, or when the victims are ask about whether or not the offender is being subject to certain conditions, non-communication with victims, for example. At the NDP, we're prepared to accept certain amendments to this bill, particularly with respect to the fact that victims should be able to attend parole hearings. We feel that's very, very important. We also have to give victims the possibility to attend these hearings through video conference, teleconference. I find that's a wonderful idea, especially for those who find it difficult. Perhaps they have reduced mobility, such as the example you gave in your presentation. Some victims work, they have children, young children. I can understand that there are all kinds of reasons that can affect this decision. There are all kinds of things that can happen that prevent this from happening. But this is part of the this is a part of the legislation that's important that we study. But a question was asked earlier about the sponsor of the bill and the Victims' Bill of Rights that was promised by the Conservative government. Do you think that this should not have been part and parcel of comprehensive rights for victims? Do you think that we should have had a more comprehensive bill, such as the Victims' Bill of Rights?
Excuse me. I think we're all waiting to see what the Victim Bill of Rights will contain, and I don't know what I don't have that, so for me to speculate on what that could. What I can say is this: is that this bill does address, in part or in many ways, some of the recommendations that we have specifically already made. And so, when I got back to my comments about, if this is an opportunity to put in legislation, as was said earlier, some things might be in policy, but really to start to recognize, excuse me, to recognize that this is about informing them, it is about considering victims, and it is about supporting them. You've raised, and I thank you for that, some excellent points around, a choice and options for victims. And so would we like to see comprehensive looks in all legislation, ensuring that there's a victim's lens to make sure that they are informed, considered, protected, and supported? Yes. So we look forward to and are waiting to see what the Bill of Rights, once it's tabled. We have, as you may be aware, submitted our submission on the upcoming Victim Bill of Rights from our office, which is available on our website, as well as some of the videos I think that were referred here earlier. We held a national forum. And so when you talk to victims about, yes, they are not bystanders in the criminal justice system. They have a right to have meaningful participation. And so this bill does address directly some of the recommendations that we have made, and we look forward to see that the Victim Bill of Rights hopefully will as well address many of the needs and issues and concerns for victims of crime.
Excellent.
That's great. You referred to a report that was alluded to in Mr. Sweet's report, as the statement, rather. I quote from you, despite all of the efforts made, victims who wish to attend a hearing are obliged have to deal with the same wait times. What type of measures should we take to ensure that victims feel safer when they attend these parole hearings? You referred to this somewhat briefly in your statement, but could you elaborate on that, please?
What steps can we take to ensure that they feel safe?
Yes.
One is, I think they need to make sure that they're informed at all parts of the process. So when there are upcoming dates, that they have that information in an appropriate amount of time, that they're aware of what's required. So for example, for some victims who have never given a victim statement at a parole hearing, you have to prepare your statement ahead of time. That has to be submitted ahead of time. And then once it's submitted, you can only read that. You may not deviate from that statement. You may only read what is written at the time of the parole hearing. So there are many issues that have been brought forward to our office from victims in terms of both parole hearings and simple considerations. So for example, parole hearings take place in institutions, so they're all different. And it could be, making sure that you consider and put yourself in a victim's perspective. So if the offender is walked right by the victim on the way to the parole hearing in close proximity, then really put a lens on in terms of considering the impact to the victim. We've dealt with everything from where the victim is sitting within the room where the hearing is taking place, looking at if there is a video there is a video that an impact statement being given, where that is, and can the offender see it or not see it. And so it's really to consider all of the information, the proximity issues, and the respect issues of treating those families and those victims with dignity and respect in terms of that hearing, and all through all stages, that they are informed, that they are considered in terms of that. That's going to go a long way towards them feeling safe. And also, I think the modifications that we've recommended here, give them those choice and options, because as I said in my testimony, for some may very much want to be there in person. Some may not be able to, but still want to participate. And so, for example, one of the simple modifications we said was that, they shouldn't, even if they're denied attendance for safety reasons, or if they're denied that attendance, they should be allowed to follow. They should be allowed to give their statement using the technology, not just follow.
Thank you very much,
along.
Mrs. Sullivan.
Thank you.
And now, Mr. Richards, for 7 minutes, please.
Good, thank you, and appreciate you being here today to talk about this piece of legislation. It was good to hear a little bit about your mandate as well. I mean, certainly ensuring victims' rights are put as the top priority in our justice system has always been one of the things that I've focused on in my time here in Parliament over the last 5 years, and certainly in my own personal charitable pursuits as well. I think it's important that victims' priority is at the very top, and I'm glad to see the mandate of your office and clearly hear it in your comments and in your commitment, and I commend you for that.
Thank you.
But I do want to, of course, get to the bill at hand here, and certainly appreciate that you've given a lot of thought to it, and amendments that maybe that you may suggest would be helpful. That's very much appreciated. That you've taken the time to fully prepare in that way. I've got a couple of questions I'd like to ask specifically, and I think the first one really centers around these processes, what they often are for the victims of crime, or for the families of victims of crime. It's almost a further victimization, I think it would be a fair way of putting it. A very difficult situation that they're put through. And you've spoken to that as others have, Mr. Sweet as well with his examples. So we don't need to go into that any further, but what we do need to, what I would like to try and do for the committee, and if you could help us with any information you might have in terms of statistics, is to try to quantify how many victims are further victimized each year by these kinds of processes. So if there's any kind of stats you could share with us that give us a sense as to how many families must go through one of these situations on say maybe on an annual basis, or maybe even per offender for various types of crimes? Any kind of stats that you could give us that would help to quantify the numbers that we're talking about here, families who are victimized in this way?
So, again, I'm not Correctional Service Canada, but I think roughly in the nature of, like, in Custody Institute, 17,000. So I believe there are about 6,000 to 7,000 registered victims. So when you look at that, I think, first of all, we talk about information available to Canadians. If, in fact, you want the information that the legislation says you can have currently about an offender, you must register as a victim with Parole Board of Canada or Correctional Service Canada. So unless somebody makes you aware of that, you wouldn't know that. Otherwise, you can't have access to any of this information. And so what we do know as well is that some offenders will have more than one registered victim. So to give you a concrete, I don't have the exact number, I apologize with me today about, I can get that for you, but the number of parole hearings a year. But what I can tell you that within our mandate as the federal ombudsman, we do take complaints from victims across this country, particularly in relation to the CCRA or issues around Correctional Service Canada and the Parole Board. So it would not. So there, when you ask me, how many exactly, we deal with certain victims who contact our office or through different opportunities that I have when I'm out in different communities across this to speak to victims about these issues. So that's, I always say I don't tell their story, I amplify their voice. So those are the issues that I'm bringing forward here based on the input from the victims and the families that we speak to on a regular basis about issues that they've confronted. So I don't know if that's answering your question.
No, that's helpful. And if there is other stats or information you could provide,
I can certainly get some.
But certainly, I think to be able to give me a sense as to how many registered victims, like that, does tell, I think, a pretty good story to this committee as to the number of people that are affected by these very tragic circumstances that they have to relive over and over and over again with these hearings. And I think it kind of leads a little bit into the next question I had, which is really centers around information. I think that from everything that I've heard from victims and from individuals like yourself, it seems as though sometimes the lack of information is one of the things that's most difficult and troublesome for victims and their families in these kinds of situations. So I wanted to know if you could comment a little bit on the clause in the bill that requires the 14 days notice for the victim to be able to receive information regarding parole conditions, location, time of release. And further, and I think even more importantly, that it requires an ongoing duty to disclose that information following the initial request. Because I think often what can happen is the victim or the family doesn't really know when or how or why to sort of ask for that information. So it's difficult to know unless there's that ongoing duty to disclose. So if you could maybe just comment on that particular provision of the bill.
I think you've raised some excellent points, because really people need to be informed at every stage of the process. We can never forget who suffered the harm and the loss here. And so, to me, of course they need to have information about when they're being released back in the community. And I think that was referred to one of our videos here where, quite clearly the victim has said, here I am, in an area where they've been released on a work release where I could have come across them not knowing that. So it just makes sense that we have a system that's going to provide that information to victims and their families so that they know so that they are prepared, when they know they're coming back to the community. What are those conditions when they come back to the community? Because in many cases, some victims are released back obviously, or offenders are released back in the same community as victims. Some of them are very small communities. They may come across these people, so you've raised some excellent points about the importance of them being informed.
It just only seems like common sense to me that we would ensure that victims have access to that information. I mean,
many victims would say they'd like to see more than 14 days, but I realize sometimes
certainly, but it just seems like common sense that victims should have that information. It would be hard to imagine anyone opposing victims having access to that information to ensure that they would not be victimized again. If I still have a little bit of time, I'd like to maybe just touch on another. You did talk about it briefly in response to an earlier question from Mr. Payne, and you actually had some comments on it in your opening remarks as well in terms of some changes you'd like to see. You talked about the offender's correctional plan, and I wanted to just
hear a little bit more, if you could, from you about how important and why it's so important that the victim be made aware of that offender's correctional plan. This is, again, goes to the information that needs to be there for victims to understand the situation. If you can tell us a little bit about why that's important.
Thank you for that opportunity. I think if you look at right now, when we look at, if I can say, the PPDO, really, if you were to think of, if you got a transcript from high school or from university, it says you took this course, you completed it. And really, victims want more. They want to know, what were the risks associated to this offender? What, in fact, programming is being put in place to mitigate those risks? Have they engaged in this, really engaged towards their rehabilitation? And that's why the correctional plan is so important. And so the correctional plan is really a tool that's used by Correctional Service Canada. And that's why the modification or amendment that we're recommending is now, of course, the correctional plan would become, as you head towards a parole hearing, available to the parole board. But in terms of having that information available to victims and having a right to have that information earlier on, it would make sense that the modification, that the amendment be made that Section 26 and Section 142 would be reflective. Again, they can only give, the Parole Board of Canada and the CSC can only give a victim what the legislation allows them to.
Thank you very much. Now we'll turn to Mr. Easter for 7 minutes.
Thank you, Mr. Chair, and thank you, Ms. Sullivan, for really, I think, a very good presentation with a lot of good suggestions. You've suggested a number of amendments. Have you prepared any such amendments, or has anyone? We can go to the Library of Parliament and get some prepared for sure. But have you prepared any such amendments that you think would tidy up the areas that you're suggesting are where amendments are needed?
Just what I've prepared here verbally today, those modifications.
That's fine. I want to come back to the Section 2 that you didn't have time to complete and give you a little more time to expand on that. As I read it, there may be a problem in that some people could be released without supervision into society, and that would be a fairly substantial problem, I think, for public safety if people are released without supervision. You do say that we should discuss this issue with the appropriate subject matter expert. Do you have any suggestions? I do think that is a concern, and I think it's something that may have just been overlooked.
So my testimony, which I didn't, what I responded to questions was in terms of the risks and effectiveness of parole. It's my general understanding that there are benefits to providing offenders with the opportunity to reintegrate in the community under supervision. Now, having said that, our recommendation for people convicted of murder and for indeterminate sentences is that it be increased to 5 years. What's been added to this piece of legislation is Schedule 1, which is people, mostly offenses against, I'll say, sexual assault against children, and those offenses can carry lesser sentencing. So again, that's not my area of expertise, offender management, but I will say this. Every victim that I speak to says this. They don't want what happened to them or to happen to anyone else to happen to anyone else. And they understand that offenders will be coming back into the community. And so this is something from a victim's lens, they want to make sure that they don't reoffend. And so again, I would refer to maybe the Correctional Service Canada, obviously, or the Parole Board of Canada, who would have that expertise in terms of offender management. To answer your question?
Yeah, okay. Thank you. On the correctional plan not being provided to victims, what's the reason given at the moment for why it isn't being provided? I mean, as Blake said, it only makes sense to me, both from giving victims the understanding that the proper rehabilitation is taking place, some of their issues are being dealt with, and for the offender the fact that they can be pleased about some of the progress they've made. What's the reason? Is it a privacy issue, or what is it? Do you know?
Well, I think there might be two reasons. The correctional plans that are made for offenders carry personal information, such as personal health information, and we're not recommending, that people's private personal health information be given out. So this is a conversation, with Correctional Service Canada about what portions of that that would be relative to victims. Obviously, we're not. I'm not here supporting that people's private health information be given out, or if there's information that could risk someone's safety. So these are the kind of things that would have to be considered in what information a correctional plan is released to a victim.
But you certainly would be in favor of the broad details of a correctional plan and what an offender is doing in terms of rehabilitating their life to make them a better person in society. I mean, that should be able to be worked.
Yes, and what were the risks, and what were the efforts made to mitigate? What kind of programming were they engaged in that programming? Absolutely.
The other area that you mentioned and suggested an amendment was under Section 26 of the CCRA, rather than just what the bill amends, which is Section 142. Can you expand on that?
Sure. If you look at Section 142, it's really giving direction to the Parole Board of Canada about information. It says that the request of a victim, an offence committed by an offender, the chairperson, it says shall disclose the following. Then there's may disclose. And so this bill is recommending that portions of the may become mandatory. And what we're recommending is that those mandatory portions, because they're reflective, basically. One gives direction to Correctional Service Canada. So we're suggesting that they mirror each other. And one of the simplest examples I can use is that, it's important for example, that video. If somebody's being brought back in the community on a work release, that's under Correctional Service Canada. And so in order for Correctional Service Canada to give that information, we're saying it should be made, same as reflective here, that information should be allowed to be given and should be made mandatory. Our recommendation is all the mays and disclose should be made mandatory as well.
Okay. Last question then, Mr. Chair. In terms of the, I agree with you 100% if people can't attend the hearing, and there's lots of reasons. I'm sure what must drive some people nuts is when a hearing is established and people get prepared for it, and then all of a sudden the offender decides to not go to the parole board hearing or whatever. But what's the main reason why video is not made available? I
have had, and of course you'd be no surprise to hear that I meet with Parole Board of Canada and Correctional Service Canada on a regular basis, is that some of the reasons given is that they're worried about the failure of the equipment. So a victim is set up through video conference and the technology fails. So that's one. I understand that most of this equipment is available at the different facilities. So these are just some of the things that have been brought forward. And one of the technologies, as you may be aware, parole hearings are audio taped. But because they weren't gathered for the purpose of sharing, one of our amendments is, that they should at the very least be allowed to listen to that audio recording. And you could go to a regional office and listen to it. We're not saying give them the recording, but go and make arrangements. There's currently a fund from the federal government that allows a victim and a support person to attend a parole hearing and fund that. Maybe that fund could be expanded to people to attend the offices to listen to the audio. And even if they attended in person, they may have been so emotional as to not fully grasp all of the information that's in that parole hearing. And they may simply, could I just go and listen to the audio recording next week because I'm not sure I grasp everything that was there. But currently they can't. So what we're saying is that they should be, and that should be funded as well. The other thing I do want to flag as well is obviously if there are people who have accommodation issues such as hearing impaired, then a transcript should be made available.
Thank you very much, Mr. Sullivan. Maintenant, Monsieur Dussault, for 5 minutes.
Merci beaucoup.
Mr. Dussault, 5 minutes. Thank you. The problem I have with this bill is that we're creating only one category of criminal offender, in the sense that there are some offenders who may be serving a sentence of less than 5 years. They'll only have one hearing, but so as a result, if the first request is turned down, it's quite possible that they may be paroled without a review. And I'll give you an example. Let's say there's someone who drives drunk, recognized not criminally responsible for a death, but they spend 3 years in jail. Same situation with domestic violence, people who are repeat offenders time and again, and who are released without ever having had a hearing or without having any follow-up with respect to their rehabilitation. So I'm wondering, with a bill like this one, how are these people who have jail times of 5 years or less, how are the victims, or how is society going to see that these people have been rehabilitated? Because there's always a risk to the public danger. Could you comment on that, please?
In terms of the whole issue of rehabilitation, and there are certainly people who are much more expertise than I do, but I will say this bill does have states within 5 years. So that in relation specific to this bill, I think that, that the board still has leeway to exercise its authority. It says within 5 years. If you're talking about the bigger issue of just rehabilitation in general, I don't think the next 3 minutes that either of us can. It's such a huge, and you've touched on such important issues. And I think you've touched on something that many victims talk about is, as you say, not everybody is rehabilitated. People do come back. We know there's offenders that come back into communities with high-risk notifications on them, that they ever a high risk to reoffend. And so these are the challenges that we as a society have.
I have some time remaining? Yes. On the same topic, do we need to take some protection measures with respect to the communication of information provided for by the bill? Are there any measures that are going to protect victims from any revenge from offenders who, perhaps an offender could want to seek revenge on a victim who has asked for information on them?
Where we all need to be, Correctional Service Canada, Parole Board Canada victims, we all need to be talking about if there's any information that comes up and poses a risk, then obviously safety planning and information for victims is obviously going to have to be undertaken. And so in terms of this legislation, I think to address from a victim's lens, and I talked about that in my testimony, some may fear that retaliation, some may fear going in person. This is why those choice and options are so important, to give them whatever they're comfortable with in terms of their level of participation, be it in person, be it by video conference, be it by other technology. So I think if we were to look at the modifications we put here, that would be helpful for victims to have those choice and options.
Merci, Monsieur Rousseau.
Thank you, Mr. Rousseau.
Minutes, please.
Thank you, and I want to thank you, Mrs. Sullivan, for your passion, the same as Mr. Sweets, in regards to the presentation on this Bill C-479. This is you can certainly appreciate your direct understanding of the need for a bill like this, and I sense that you've got a desire to see greater victim rights here as well, obviously. The multiple media stories that we hear lately and over time regarding victims and victims' families, where they're shocked, maybe not horrified in some cases, about the release of offenders, receiving parole and being released close to their homes. Do you feel that the measures here in this bill will help to prevent that situation from occurring and preventing more of the situations where they'll be placed in a detrimental position?
Yeah, I think a lot of the measures here are going to, if the modifications are adopted, are going to significantly address the treatment of victims within the criminal justice system. I think there's this will go a long way. I think we still have work to do. I think that our office has many other recommendations out that we're hoping will also be brought forward either through the Victim Bill of Rights or other legislation in terms of addressing these four main issues, but particularly about the consideration. I talk about victims feeling protected. It's exactly what you're speaking to, which is that they need to know that their safety has been considered by the decision makers in the criminal justice system, and that includes the Parole Board of Canada. And so they need, how are they going to know that their safety is considered? I think sometimes people say, well, no, of course it is. We factored into that. But when people are making decisions and that they have a right to be heard about what their considerations and their concerns are through their victim statements, and if they're given choice and options around how to do that, that's going to go a long way to ensure that they feel that the board has heard what their concerns are. I think that there will always be issues in relation to decisions that are made, and certainly our office continues to hear from victims on many of those issues, and a lot of our recommendations that come out of our office come directly from complaints and issues that are brought forward to us. In matter of fact, our recommendation for the 5-year increase came directly from victims who have brought those issues forward to our office.
Thank you. And I know that the legislation is geared to provide victims with a greater voice in the whole parole process. And I think that's key to this whole thing is exactly what can we do to enhance the victim's input into the process. Part of the reason for doing that is obviously there's a healing process that they go through, and you've outlined in your passionate presentation, I could say today as well, many areas of improvement and concern in the bill, and backing Mr. Sweet's presentation. Do you think that the recommendations that he's put forward today will enhance that healing process? Is it enough to enhance the victim's healing process in this whole
I think when it comes down to what helps victims, and you say in their healing process, and I made the comment in my testimony, every victim is unique. There are many victims whose sentencing is a huge issue. There are others who restorative justice, offender mediation. So, and along their journey, those choices may change. And so if we put in place through legislation and through how we do business, if you will, through policy and the rest, that we put in place measures that are going to respect victims, that are going to ensure that they are heard, that they are considered, that they have input, meaningful participation in this process, that's going to go a long way, because you will hear, victims need to be respected and treated with dignity in this process. And so legislation that's going to allow them to have the information they need in a timely way, that's going to inform them, that's going to ensure that they have the information about the offender who harmed them, that they know whether or not they're taking every sincere effort to rehabilitate, or conversely they're not. So I think this is going to allow these steps and the proposals, and particularly if the amendments are accepted or the suggestions, are going to go a long way towards that.
Very briefly, please.
And so, just finally, you feel that, as put forward, this will do that, this bill will do that?
Well, I think it will lend itself, for healing many of the things which often, as you know, the direct services to victims of crime are the responsibility of provinces and territories. And many victims, the healing process is also just about things like counseling and having, opportunities to people to support them through the process. And many times when you talk to victims, their needs and their process is a lifelong process that goes well beyond the criminal justice system. Thank you.
Thank you. This time, having had questions from 3 government members, 3 opposition members, I'm, as the chair, going to thank Ms. O'Sullivan for her valuable contributions
to
our deliberations on this bill. And also, I know that while I've been on this committee, she's been here many times and has been a continuing assistance to us. So thank you very much.
Thank you for the opportunity.
So we will now suspend for 2 minutes to go in camera. Members, staff may stay. And I'm just going to say, I've checked with the clerk. According to the rules, the committee may allow Mr. Sweet to stay if he'd like to stay for this. And so if I see no objection, I will invite Mr. Sweet to stay with us in the in-camera session.